Good morning, friends. Today we are going to deal with a very important topic in the law of the Constitution. And the area is Article 13 of the Indian Constitution. As you know, Article 13 is a very famous article with a reference to a doctrine called the Doctrine of Judicial Review. But in today's class, we are going to deal with a different aspect of Article 13, that is, three doctrines connected to Article 13 of the Constitutions. These doctrines, as you know, are being asked for examinations almost every year. Now, there are so many doctrines connected with it. The three major ones which we are going to deal today is one, the Doctrine of Severability, second, the Doctrine of Eclipse, and third, the Doctrine of WAIVER. So these are the three doctrines which are repeatedly being asked in question papers. So even though the area which is dealt by me is Article 13, we are gravitating or going to gravitate around these three areas, these three doctrines. So you know that Article 13 is the second article in Part 3. And Part 3 of the Constitution deals with what you call fundamental rights. The first article of the fundamental right is Article 12. And the second article is Article 13. Now, Article 13 is very important because it deals with judicial review, it defines law, and as a corollary to these particular doctrines or these particular concepts, certain doctrines which I have stated earlier had come out of it. So they are the doctrines of severability, doctrines of eclipse, and the doctrine of waiver. Now, before we start with each one of it, let's try to understand the article as it is, or the part of the article which is important to us. Article 13 കുറച്ച് വലിയൊരു ആർട്ടിക്കിളാണ്. അതിൽ നമുക്ക് പ്രധാനപ്പെട്ടതായിട്ടുള്ള ഭാഗം ആർട്ടിക്കിൾ 13 പാർട്ട് 1 and 2 അത് നമുക്കൊന്ന് വിശകലനം ചെയ്യാം. Now, Article 13 part 1 or first part says that it is with regard to before that, you know that after the Constitution came into existence in 1950. Most of the laws which we see in India now, or a huge chunk of the law which we see now, നമ്മൾ ഈ കാണുന്ന മുഖ്യ നിയമങ്ങളിൽ ഒരുപാടുണ്ട്. They were created before the coming of the Constitution. For example, the Indian Penal Code in the 19th century, 1860s, Indian Evidence Act, again before the Constitution. Transfer of Property Act was created before the Constitution during the period of the Britishers. Thus, a huge chunk of the law in India was created before the Constitution. So you are aware of it, but you keep that in mind. അപ്പം ഒരുപാട് നിയമങ്ങൾ നമ്മളിപ്പോൾ കാണുന്നത് നമ്മുടെ ഭരണഘടന ഉണ്ടായതിന് മുമ്പ് ഉണ്ടാക്കിയതാണ്. അതെല്ലാം ഇപ്പോഴും ഉണ്ട്. So Article 13 deals with matters involving law and their constitutionality. Now, what was the change which was produced by the Constitution and the fundamental right? One major change which was produced by the Constitution is that after the constitution was made, all the laws in India should conform to the fundamental rights under part 3 of the constitution. അപ്പോൾ നമ്മുടെ ഭരണഘടന ഉണ്ടായതിനു ശേഷമുള്ള മുഖ്യമായ ഒരു മാറ്റം എന്ന് പറയുന്നത്, ഭരണഘടനയ്ക്ക് ശേഷം ഇന്ത്യയിൽ നിലനിൽക്കുന്ന എല്ലാ നിയമങ്ങൾ തന്നെ മൗലിക അവകാശം എന്ന് പറയുന്ന ഭാഗം 3 പറയുന്ന അവകാശങ്ങളുടെ ലംഘനമാകാൻ പാടില്ല. Or every law in India should conform to the standards of part 3 fundamental rights of the Indian Constitution. Now this is the background. Now let's see how it is being formulated in the Constitution. Article 13, Part 1 and Part 2 specifically deals with unconstitutionality of laws which are inconsistent with fundamental rights. ഭരണഘടനാ വിരുദ്ധം, മൗലിക അവകാശങ്ങൾക്ക് വിരുദ്ധമായ നിയമങ്ങളുടെ കാര്യങ്ങളെ കുറിച്ച് പറയുന്നതാണ് 13 ഭാഗം 1 ഉം 2. So the first part of Article 13, let's see what is the first part of Article 13. I am going to give the gist of it. I am not going to produce it in verbatim. I am going to just give the gist of it. 13.1 says that all laws in India at the commencement of the Constitution, all laws in force in the territory of India at the commencement of the Constitution shall not be inconsistent with fundamental rights guaranteed under Part 3 of the Constitution. And if they are inconsistent with the fundamental right, to the extent of the inconsistency, such laws will be void. ഭരണഘടന ഉണ്ടാകുന്നതിന് മുമ്പ് നിലനിന്നിരുന്ന നിയമങ്ങൾ ഭരണഘടന ഉണ്ടായതിനു ശേഷം ഭരണഘടനയുടെ 3-ാം ഭാഗത്തിലുള്ള മൗലിക അവകാശങ്ങളുടെ ലംഘനമാകാൻ പാടില്ല. അങ്ങനെയുള്ള നിയമങ്ങളിൽ ഏതെങ്കിലും ഭാഗം ഭരണഘടനയുടെ 3-ാം ഭാഗത്തിലെ മൗലിക അവകാശങ്ങളുടെ ലംഘനമാണെങ്കിൽ അവ അത്രത്തോളം അസാധു ആയിരിക്കും. So no law which existed in India before the Constitution shall be inconsistent with the fundamental rights laid down in Part 3 of the Constitution. And if any such law is inconsistent with the Part 3 of the Constitution after the creation of the Constitution, then such law, to the extent of inconsistency, will be void. So the pre-constitutional law, if it happens to be in conflict with any of the fundamental rights under Part 3, then to the extent of the inconsistency, it will be void after the passing of the Constitution. I hope you get it. So this is the part 1 of Article 30. That is, any pre-constitutional law which violates a fundamental right after the passing of the Constitution shall be, to the extent of inconsistency, void. Part 1. Now you come to Article 13, Part 2. Article 13, Part 2 deals with laws which are created in India after the passing of the Constitution. Earlier it was before the Constitution, and now comes to laws which are created after the Constitution. Under this particular part, state shall not make any law, that is after the passing of the Constitution, state shall not make any law in contravention to any of the right guaranteed under Part 3 of the Constitution, that is the fundamental right. So after the passing of the Constitution, the state cannot make any law violating the Part 3 of the Constitution, that is the fundamental rights. And if any such law which is made is found to be violative of fundamental right, such law to the extent of the contravention of the fundamental rights shall be void. രണ്ടാമത്തെ ഭാഗം പറയുന്നത് ഭരണഘടന ഉണ്ടായതിനു ശേഷം മൗലിക അവകാശങ്ങളെ ലംഘിക്കുന്ന നിയമങ്ങൾ ഉണ്ടാക്കാൻ പാടില്ല. അങ്ങനെ ഏതെങ്കിലും നിയമം ഉണ്ടാക്കി അതിൽ ഏതെങ്കിലും ഭാഗം മൗലിക അവകാശങ്ങളെ ലംഘിക്കുന്നുണ്ടെങ്കിൽ എത്രത്തോളം അവ ലംഘിക്കുന്നു അത്രത്തോളം അത് അസാധുവായിരിക്കും. So that is the second part. So it is very obvious and very clear that pre-constitutional law violating the fundamental rights to the extent of inconsistency will be void. After the passing of the Constitution, any law in contravention of the Part 3 of the Constitution to the extent of the contravention will be void. This is the supremacy of the fundamental rights over the laws made in this country. And if suppose you have a feeling that one particular law is violative of the Constitution, what is your remedy? Then you can file a case directly to the Supreme Court under Article 32 of the Constitution or to the High Court under Article 226 of the Constitution. With this background, we will start with the fifth maxim or the fifth concept, Doctrine of Severability. Severability means that which can be severed. Severed means that which can be separated. മാറ്റാവുന്നത്, വിഭജിക്കാവുന്നത്. അതാണ് സെവറബിലിറ്റി എന്ന് സെവറൽ എന്നൊക്കെ പറയില്ല. Now what is severability? Now, when a law violating fundamental rights is challenged before the Supreme Court or the High Court, a law which is violating the fundamental rights is challenged as unconstitutional before the Supreme Court and the High Court. The court finds that not the whole of the law, only some sections or one section of the law is violating the fundamental right, not the whole of the law. ഒരു നിയമം ഭരണഘടനാ വിരുദ്ധമാണെന്ന് പറഞ്ഞ് നമ്മൾ ചലഞ്ച് ചെയ്യുമ്പോൾ കോടതി നോക്കുമ്പോൾ ഈ നിയമം മുഴുവനായി ഭരണഘടനാ വിരുദ്ധമല്ല, അതിൻ്റെ ഒരു സെക്ഷനോ 2 സെക്ഷനോ അര സെക്ഷനോ whatever it is, it is found to be violative of fundamental right, but the rest of the law is valid. ബാക്കിയുള്ള ഭാഗം clear. So if only a part of a law is valid, I mean invalid as violative of the Constitution, and the rest of the law is valid, and if the part which is in violation of the fundamental right can be severed, That means it can be divided and set apart. Then the whole law will not be held invalid, but only that part which is violating the fundamental rights will be held invalid, and that part will be invalidated, and the rest of the law will be held valid. ഒരു ഭരണഘടനാ വിരുദ്ധമായ നിയമം കോടതിയിൽ ചെല്ലുമ്പോൾ കോടതി മനസ്സിലാക്കുകയാണ് അതിൽ ഒരു സെക്ഷനോ ഒരു മുറി സെക്ഷനോ ആണ് ഇൻവാലിഡ് എങ്കിൽ ആ ഭാഗം മാറ്റപ്പെടാവുന്നുണ്ടെങ്കിൽ അതിനെ മാറ്റിയിട്ട് ബാക്കിയുള്ള ഭാഗം വാലിഡ് ആണെന്ന് കോടതി പറയും. This is called Doctrine of Severability. So it means that if an unconstitutional law is challenged and the court sees that only a part of it is invalid and rest valid, and the part which is invalid can be separated or severed, then that will be separated and the rest of the law will be held valid, and only that part will be held void. This is called Doctrine of Severability. But one point has to be kept in mind, that is, if major part or the very core of the law itself is invalid and that part cannot be severed, then the whole law will be void. ഒരു നിയമത്തിലെ മുഖ്യമായ ഭാഗങ്ങളെല്ലാം ഭരണഘടനാ വിരുദ്ധമാണെങ്കിൽ അത് എടുത്തു കളയാനും പറ്റില്ല എന്നുണ്ടെങ്കിൽ, അങ്ങനെയാണെങ്കിൽ ആ മുഴുവൻ നിയമവും അസാധുവായിരിക്കും. If only a part of it is invalid and that can be separated, then the rest of the law will be valid. This is called Doctrine of Severability. And there are two major cases. Like in other videos, I'll be referring only to two cases. The first case in this regard is A.K. Gobarin versus state of Madras. It happened when the Madras state existed. Now here, in this case, A.K. Gobarin, the very famous communist leader, was put in prison under a law called the Preventive Detention Act. Preventive Detentions Act are an extraordinary laws, and when you are placing a person under arrest under the Preventive Detention Act, you cannot easily get a bail. The restrictions like he should be produced before a magistrate within 24 hours and all these things are not applicable when you are arresting a person under the Preventive Detention Act. So when AKG or A.K. Gobarin was put under the Preventive Detention Act, he challenged the whole act itself. I think his lawyer was the father of the present Attorney General K.K. Venugopal, Mr. Nambiar, a very famous lawyer. So he appeared on behalf of A.K. Gobarin and he contended that the Preventive Detention Act itself is violative of the Constitution, as it is violative of fundamental rights of right to life and personal liberty under Article 21 of the Constitution. A.K. Gobaline തടവിലിട്ട Preventive Detention Act എന്ന് പറയുന്ന ഒരു ആക്ട് പ്രകാരം ആ ആക്ട് തന്നെ ഭരണഘടനാ വിരുദ്ധമാണെന്ന് പറഞ്ഞിട്ടാണ് കേസ് പോയത്. So the court perused the whole thing, analyzed the facts, the law, and found out that one particular section, section 14 of the Preventive Detention Act, is violative of the Constitution. The court discovered that in the Preventive Detention Act, one particular section, that is section 14, is violative of the Preventive Detention Act. Section 14 violation. But the court further found that this section 14 can be separated from the whole statute. Preventive Detention Act il ninnu ee 14 മാത്രമായിട്ട് നമുക്ക് എടുത്ത് മാറ്റാം, വലിയ പ്രശ്നമൊന്നുമില്ല. So the court held that the Preventive Detention Act section 14 is invalid, but rest of the law is valid. ബാക്കിയുള്ള ഭാഗങ്ങൾ it is constitutionally valid, but the portion which is violative of the constitution, that has quashed and invalidated. So here the law which is applied, or the principle which is applied, is our doctrine of severability, that the part which can be separated or severed, that can be invalidated, and the rest of the statute will be valid. Now that is A.K. Gobarin's case. Now the second case is RMDC versus Union of India. RMDC versus Union of India. In this particular case, the act which was challenged was the Price Competitions Act. Price Competitions Act was an act which prohibited mainly gambling competitions in the nature of the gambling. But gambling മാതിരിയുള്ള കാര്യങ്ങൾ തടയാൻ വേണ്ടിയിട്ടാണ് ഈ പ്രൈസ് കോമ്പറ്റീഷൻ ആക്ട് ഉണ്ടാക്കിയത്. Now under section 2 of that particular act, there was a confusion. You know what is the confusion? Price competitions can be competitions purely of gambling nature, and it can also be competitions involving skill. നമുക്ക് സ്കില്ലുള്ള ഗെയിംസ് ഉണ്ട്, സ്കിൽഡ് ഗെയിംസ് എന്ന് പറഞ്ഞാൽ നമ്മൾ ഈ സർക്കസിലൊക്കെ കണ്ടില്ലേ, things like you just throw a ring and suppose that it falls on a particular thing, you will get that thing. So it involves gambling. It's not purely gambling, it involves skills also. The objective of the Price Competition Act was to prohibit gambling. But under section 2, the definition will include both price competitions purely gambling and price competitions involving skill. അപ്പോൾ ഇതേമാതിരി സ്കില്ല് വേണ്ട കളികളെയും it will come into the category of gambling. So it was challenged as violative of several articles of the constitution, like fundamental rights of article 14 etc, 19(1)(g) or so many. They challenged it. So on perusing the fact, the court held that the part of the law which prohibited skilled games is unconstitutional. For skilled games in a prohibited in a bhagam, that is unconstitutional. But the rest of the part dealing with purely gambling competition, that is valid. Bakiyulla bhagam valid. And the part dealing with the skill games, part dealings with the skill games can be separated. Or the part dealing and the skill games and gambling, that those parts can be separated. So the court held that the unconstitutional part can be separated, and that will be invalidated, but the rest of the statute will be valid. അപ്പോൾ ഭരണഘടനാ വിരുദ്ധമായ ഭാഗം മാറ്റിയിട്ട് ബാക്കിയുള്ളത് വാലിഡ് ആവും. So the part dealing with the gambling, prohibition of gambling will be valid, but the part prohibiting skill games will be invalid. So this is the second case, the case of RMDC. So this is the law relating to Doctrine of Severability, which is a part of Article 13(1) of the Constitution. Now you come to the second part, or the second principle in 13(1), that the Doctrine of Eclipse. Doctrine of Eclipse mainly deals with pre-constitutional law. We have seen that the laws which exist at the time of the commencement of the Constitution contains any provisions which are inconsistent with the fundamental right, then that law to the extent of the inconsistency will be void. This is what is stated. Now, regarding a pre-constitutional law, there is an interesting aspect. Just imagine a pre-constitutional law. This pre-constitutional law, when the Constitution comes, has some provisions which is violating the fundamental rights. So just consider this to be the pre-constitutional law. And when the Constitution comes, there are provisions in the Constitution which violate the pre-constitutional law. In such a case, the pre-constitutional law will not be totally void. ഇപ്പോൾ ഭരണഘടനയ്ക്ക് ഉണ്ടായതിനു ശേഷം ഭരണഘടനയ്ക്ക് മുമ്പുള്ള ഏതെങ്കിലും ഒരു നിയമത്തിലെ കുറച്ച് ഭാഗം ഭരണഘടനാ വിരുദ്ധമാണ്. അങ്ങനെയാണെങ്കിൽ ആ നിയമം മുഴുവനായിട്ടില്ലാതാവുന്നില്ല. So the pre-constitutional law in violation of the fundamental rights after the passing of the Constitution will not be totally void. Only thing is that they will be overshadowed by the Constitution. This law will be overshadowed by the Constitution. Or in other words, just like a moon or a sun getting eclipsed by the other planet, the pre-constitutional law violating the fundamental rights will be eclipsed, shadowed by the Constitution. So as a result of the shadow of the Constitution, we can't see that law. അപ്പം ഭരണഘടന ഉണ്ടായതിനു ശേഷം ഭരണഘടനയ്ക്ക് മുമ്പുള്ള ഒരു നിയമത്തിലെ ഭരണഘടനാ വിരുദ്ധമായിട്ട് എന്തെങ്കിലും ഉണ്ടെങ്കിൽ ആ നിയമം ഭരണഘടന ഉണ്ടാവുന്നതിന് ശേഷം ഭരണഘടനയാൽ ഒരു നിഴല് കൊണ്ട് മൂടപ്പെടുകയാണ്. That is being shadowed by the Constitution. But it is not totally void. പക്ഷെ അത് ഇല്ലാതാവുന്നില്ല, ആ നിയമം ഇല്ലാതാവുന്നില്ല. That law is never destroyed. Only thing, it is overshadowed by the Constitution. Or the Constitution casts a shadow on that particular law that we can't see it. Now, by any particular change, amendment of the Constitution, if by amendment of the Constitution, if the conflict between the Constitution and the pre-constitutional law is removed, ഭരണഘടനയുടെ ഒരു അമെൻമെന്റ് വഴി ഈ ഭരണഘടനയ്ക്ക് മുമ്പുള്ള നിയമത്തിൻ്റെയും ഭരണഘടനയുടെ മൗലികാവകാശങ്ങളും തമ്മിലുള്ള വൈരുദ്ധ്യം മാറപ്പെടുകയാണെങ്കിൽ, just like the sun coming out of the shadow or the moon coming out of the shadow, the law will also come out of the shadow of the Constitution. So, if the conflict between the fundamental rights and this particular pre-constitutional law is gone as a result of the amendment, then that law will revive or come back out of the shadow. This is called Doctrine of Eclipse. So, a pre-constitutional law which violates the fundamental rights will not be totally void. It will be only shadowed by the Constitution. After the conflict is gone, the law will revive or come back. This is called the doctrine of eclipse. There is one major case in that particular category and two other cases related to it. The major case is Bikaji Narayan versus State of UP. Bikaji Narayan versus State of UP. Now, what are the facts of the case? This case happens in 1950, before the state reorganization. During that time, there was a state maybe called the Central Province. Maybe that is Madhya Pradesh. Now, there was a law in Central Province which stated, the name of the law is CP and Bearer Motor Vehicles Act. CP and Bearer Motor Vehicle Amendment Act. Under this particular act, CP and Bearer Motor Vehicle Amendment Act, the state had given, or state was given the power to take over motor vehicle transport within its territory. To take over motor vehicles transport within the territory, excluding private persons. That is something like they can have a monopoly. So this was the law. Now, what is the effect of the constitution is that when the constitution was passed, there is a article called 19(1)(g) which says that every person will have the freedom of trade and profession within the territory of India. Or that is the freedoms of 19(1), freedom of speech and expression, assembly, association, movement, residence, and freedom of trade and profession. 19(1)(g). So under that particular fundamental rights, everyone has a right to run a business, including a right to ply transport vehicles, private buses and things like that. So when this fundamental right to freedom of trade and profession came, the problem is that in CP and Bearer, no private individual has the right to start a transport service. And that became violative of their freedom of trade and profession under Article 19(1)(g). So CP, Bearer and Motor Vehicles Amendment Act comes in direct conflict with the fundamental right to freedom of trade and profession and was shadowed by the Constitution, eclipsed by the Constitution. It was eclipsed by the Constitution. So it has lost its validity. But it is not destroyed. It is not destroyed. It is remaining there. Then what happened? After some time, the first amendment of the Indian Constitution came. When the amendment of the Indian Constitution came, a provision was added in the Article 19. And under that provision, state was given the power to monopolize business. Now you know that state is given powers to monopolize business. Many of the business you can see is monopolized by the state. For example, in state of Kerala, the power to deal with sale of foreign liquor, it is monopolized by the state. So the first 19(1), 19(2) and the other restrictions. In Article 19, an amendment was made which provided the state to monopolize a trade. Then what happens? State in monopolize cheyam ennu vannappoz endu sambhavichu? CP and Bearer Amendment Acts had the objective of monopolizing trade. And it was considered to be violative of 19(1). But when 19, and when 19 itself was amended, enabling monopolization of business, what happened? The conflict between CP and Bearer Motor Vehicles Amendment Act and the Constitution is gone. Bharanaghatana amendment കൊണ്ട് തന്നെ സ്റ്റേറ്റിന് മൊണോപ്പൊളൈസ് ചെയ്യാവുന്ന വന്നു കഴിഞ്ഞപ്പോൾ പിന്നെ ഭരണഘടനയും ഈ CP Berar and Motor Vehicles Actile പ്രശ്നവും തമ്മിലുള്ള കോൺഫ്ലിക്റ്റ് വൈരുദ്ധ്യം പോയി. In such case, what happens? In such case, the overshadowed eclipse law will come back, revive. So this is a classic example to understand the doctrine of eclipse. That is an unconstitutional law, a pre-constitutional law, which is violative of the fundamental rights, is not totally eclipsed. I mean, it's not totally void. It's only eclipsed when the conflict between the fundamental rights and the law is put to an end by some amendment or some changes. The overshadowed or the shadowed law will come out. So that is called the doctrine of eclipse. Now here there is another question. What about a law which was created in India after the passing of the constitution, which has provisions which are unconstitutional? That is, after the passing of the constitution, a law is made. And there are provisions in that law which is violating the constitution. What is the effect of it? In certain cases like Deep Chand, the Supreme Court had held that post-constitutional laws violating the fundamental rights are a stillborn child. They are legal, as the legal usage go, void ab initio, or they are not existing in the eye of law. And there is no need for doctrine of eclipse. That is, they cannot come out, they cannot revive and things like that. This was the, because after the passing of the constitution, no laws can be made violating the constitution. So this is void. This is a stillborn baby. That was the observation in cases like Deep Chand. But later in state of Gujarat versus Ambika Mills, the case of Gujarat and Ambika Mills, Supreme Court has came with another rider to it. The Supreme Court held that a law made in India after the constitution, if it is in violation of the fundamental rights, will not be totally void, because fundamental rights, most of the fundamental rights are available only to the citizens. Only to the citizens. Some of them right equality is applicable to everyone. But majority of the fundamental rights are available to the citizens. So post-constitutional law violating fundamental rights can be valid with regards to a foreign person, because he can't claim fundamental rights. So that was a change with regard to these particular aspects. So there can be new and new interpretation to that aspect of law. It can happen. Now we will have the third principle, that is the doctrine of WAIVER. Doctrine of WAIVER. It's a very small thing. WAIVER means to give up, to forsake. The question is whether you can say that I have forsaken my fundamental right, so I don't need a fundamental right. That whether you can say that I am going to commit suicide because I don't require right to life and personal liberty. It is my choice. There is another ramification for this particular right to die, but I am just giving an example. That is, can you forsake or waive your fundamental right? In American Constitution, there was a doctrine which to a certain extent allowed forsaking or waiving of your fundamental right. However, in India, the concept is different. In India, it was clearly stated in the Bashir Nath versus Income Tax Commissioner that your fundamental rights cannot be waived. So the fundamental rights cannot be waived. The fact is somewhat interesting. It is some different facts. but it will take a lot of time, so I am ending it here. So this is the doctrine. These are the three important doctrines, major doctrines, with regard to what you call Article 13 of the Indian Constitution.